personality assessment tools, and not in isolation. It is often used within individual psychotherapy, marital counseling, or vocational counseling. Marital compatibility in its simplest form, only sexual expression and sexual response are examined. At its most complex, every aspect of an individual is examined for how it affects the other individuals within the relationship. The theory is that after knowing and understanding how each individual in the relationship differs from every other individual in the relationship, the resulting marriage will be more enduring. Medical diagnosis. Medical graphology is probably the most controversial branch of handwriting analysis. Strictly speaking, such research is not graphology as described throughout this article, but an examination of factors pertaining to motor control. Research studies have been conducted in which a detailed examination of handwriting factors, particularly timing, fluidity, pressure, and consistency of size, form, speed, and pressure are considered. In the process of evaluating patients and their response to pharmacological therapeutic agents, the study of these phenomena is a byproduct of researchers investigating motor control processes and the interaction of nervous, anatomical, and biomechanical systems of the body. The Vanguard Code of Ethical Practice, amongst others, prohibits medical diagnosis by those not licensed to do diagnosis in the state in which they practice. Graphotherapy. This is the pseudoscience of changing a person's handwriting with the goal of changing features of his or her personality, or handwriting analysis in reverse. It originated in France during the 1930s, spreading to the United States in the late 1950s. The purported therapy consists of a series of exercises, which are similar to those taught in basic calligraphy courses, sometimes in conjunction with music or positive self-talk. Forensic linguistics. Forensic linguistics, legal linguistics, or language and the law, is the application of linguistic knowledge, methods, and insights to the forensic context of law, language, crime investigation, trial, and judicial procedure. It is a branch of applied linguistics. There are principally three areas of application for linguists working in forensic contexts: understanding language of the written law, understanding language used in forensic and judicial processes, and the provision of linguistic evidence. The discipline of forensic linguistics is not homogeneous. It involves a range of experts and researchers in different areas of the field. History. The phrase forensic linguistics first appeared in 1968 when Jan Svartvik, a professor of linguistics, used it in an analysis of statements by Timothy Don Evans. It was in regard to reanalyzing the statements given to police at Notting Hill Police Station, England, in 1949 in the case of an alleged murder by Evans. Evans was suspected of murdering his wife and baby and was tried and hanged for the crime. Yet, when Svartvik studied the statements allegedly given by Evans, he found that there were different stylistic markers involved, and Evans did not actually give the statements to the police officers as had been stated at the trial. Sparked by this case, early forensic linguistics in the UK were focused on questioning the validity of police interrogations, as seen in numerous famous cases, e.g. the convictions of Derek Bentley, the Guildford 4, the Bridgewater 3, etc. Many of the major concerns were of the statements police officers used. Numerous times the topic of police register came up, this meaning the type of stylist, language, and vocabulary used by officers of the law when transcribing witness statements. Moving to the U.S. and the beginnings of the field of forensic linguistics, the field really began with the 1963 case of Ernesto Miranda. His case led to the creation of Miranda rights and pushed focus of forensic linguistics on witness questioning rather than police statements. Various cases came about that challenged whether or not suspects truly understood what their rights meant, leading to a distinction of coercive versus voluntary interrogations. During the early days of forensic linguistics in the United Kingdom, the legal defense for many criminal cases questioned the authenticity of police statements. At the time, customary police procedure for taking suspects' statements dictated that it be in a specific format, rather than in the suspect's own words. words. Statements by witnesses are very seldom made in a coherent or orderly fashion, with speculation and backtracking done out loud. The delivery is often too fast-paced, causing important details to be left out. Forensic linguistics can be traced back as early as 1927 to a ransom note in Corning, New York. As the Associated Press reported in Think Corning Girl wrote, ransom note, Duncan McClure, of Johnson City, uncle of the kidnapped girl, is the only member of the family to spell his name McClure instead of McClure. The letter he received, supposedly from the kidnappers, was addressed to him by the proper name, indicating that the writer was familiar with the difference in spelling. Other work of forensic linguistics in the United States concerned the rights of individuals with regard to understanding their Miranda rights during the interrogation process. An early application of forensic linguistics in the United States was related to the status of trademarks as words or phrases in the language. One of the bigger cases involved fast food giant McDonald's claiming that it had originated the process of attaching unprotected words to the Mc prefix, referred to as McWords, and was unhappy with Quality International's intention of opening a chain of economy hotels to be called McSleep. In the 1980s, Australian linguists discussed the application of linguistics and sociolinguistics to legal issues. They discovered that a phrase, such as the same language, is open to interpretation. Aboriginal people have their own understanding and use of English, something that is not always appreciated by speakers of the dominant version of English, i.e., white English. The Aboriginal people also bring their own culturally based interactional styles to the interview. The 2000s saw a considerable shift in the field of forensic linguistics, which has been described as a coming of age of the discipline. Not only does the field have professional associations such as the International Association of Forensic Linguistics, IAFL, founded in 1993, and the Austrian Association for Legal Linguistics, AALL, founded in 2017. It can now provide the scientific community with a range of textbooks, such as Coulthard and Johnson, 2007, Gibbons, 2003, and Olson, 2008. Areas of study. The range of topics within forensic linguistics is diverse, but research occurs in the following areas. The language of legal texts. The study of the language of legal texts encompasses a wide range of forensic texts. That includes the study of text types and forms of analysis. Any text or item of spoken language can potentially be a forensic text when it is used in a legal or criminal context. This includes analyzing the linguistics of documents as diverse as acts of parliament or other lawmaking body, private wills, court judgments, and summonses in the statutes of other bodies, such as states and government departments. One important area is that of the transformative effect of Norman French and ecclesiastic Latin on the development of the English common law, and the evolution of the legal specifics associated with it. It can also refer to the ongoing attempts at making legal language more comprehensible to laypeople. A forensic linguistics understanding of the relationship between language and law has been voiced by Lyser, who states that it is indeed hard to deny that the rule of law is in fact the rule of language. It seems that there cannot be law without language. Kelson, 1945-161, wrote that, "Just as everything King Midas touched turned into gold, everything to which the law refers becomes law, i.e. something legally existing. The concept of law is conveyed and mediated entirely through the structures of human language, and it is thus plausible to assume that everything the law touches is, therefore, also touched by language. This is particularly evident in the fact that all processes of legal meaning-making and meaning-seeking are inextricably tied to the language system. Monsieur is defined as a set of linguistic signs which is ascribed the societal power to control human conduct. One part of the language of legal texts encompasses the Miranda warning in the United States. These warnings let the defendant know that they have the right to be silent, since whatever they say from the point they they are in police custody can and will be used against them in a court of law. The recipients who are advised of these rights must have a certain level of competency in the English language in order to completely understand the warning. The language of legal process. Among other things, this area examines language as it is used in cross-examination, evidence presentation, judges' direction, police cautions, police testimonies in court, summing up to a jury, interview techniques, the questioning process in court, and in other areas such as police interviews. Police officers use specific language to elicit certain responses from civilians. Because of a police officer's social stature and the way they often phrase requests as commands, people may be confused as to what their rights are when they are being questioned by police. Officers use linguistic tactics including putting the blame onto the victim and asking questions with ambiguous phrasing to elicit specific responses from people. Solon, Ellen Tiersma, p. 2005. A defendant using ambiguity in the courtroom may present issues and be deemed unacceptable. Specifically, when a victim is invoking their right to a lawyer, there are directions stating that the request may not come off as ambiguous. In fact, if the request is not stated in a way that the officer deems to be clear, the victim may not receive their request for counsel at all. Refer to the following link to explore an example through the Louisiana vs. Demesme case. During the examination process, language plays a substantial role in the presentation of a story to the courtroom. Specifically, the language used by the lawyer to construct the story.